All right, Josh, go ahead.
Thank you. So I'll just reiterate where I left off. So there are the most crucial things, I think, in terms of settlement negotiations are to treat every case individually, but try to, as much as possible, make it consistent with other decisions of like type, and to accurately reflect the board perspective. And this is, I just will admit to being personally stunned and having difficulty accepting the fact that Ginny's not going to be around anymore. And I think we're really going to feel the loss of her, particularly with reflection of the long tenure and board perspective on all of these cases. So I want to just take a moment to honor all of the years I've worked with Ginny and how much I'm going to miss her personally.
All right. Good luck for that.
I actually don't know how I'll do this job without her. There are lots of factors to consider in settlement. Obviously, all of these are things you already know. The most important thing to know is that we don't always get cooperation from an investigated party in the investigation. Either they decline to participate, or for whatever reason they just don't respond. So quite often what we have from the investigation is a very one-sided version of what the facts are. So in that discovery process, sometimes we get additional facts. I would say it's not that often, but sometimes we get additional facts that may give a different perspective on what actually happened in the case. They may be able to point to a particular employee that we didn't know about that's responsible for most of the misbehavior, things like that. So that can change a settlement posture of a case. They might, as I said earlier, sometimes a case has been around for a while for legitimate reasons, and during that time, the person may have done a lot of stuff to either improve processes at their pharmacy, personally rehabilitate themselves, contribute to their community, do other things that might mitigate their behavior. All of that might be taken into account. That was stuff that was not known during the investigation. So there's lots of information that we might acquire during this discovery process that can change what the initial settlement offer might have been. And so one of the things we encourage client agencies to do is to send with their investigation file, when they send it to us, their initial assessment of what the case may be worth in settlement. I think there's a certain hesitancy to do that, and I understand that, because you don't want the attorney to give away the store and give that term right up front. You want them to be, calculating about when or how they might offer those terms. So I think the general tendency is to give those, when those initial settlement terms are transmitted, they're usually the most stringent, and there may actually be room for negotiation down from those. But because of some experiences where board staff haven't been happy necessarily with the way those terms were presented, I think they haven't always given what their real terms are in that initial. And then it's also impacted by this, what I just said, which is that even those initial terms can be substantially changed by new facts, or by the fact that someone's represented by vigorous counsel, or all kinds of things that might change how much you're willing to invest in a case or what you think that case is worth. So that can be a lengthy process. And as anyone who's been involved in litigation or knows anyone who knows, cases are most often settled on the courthouse steps. So if you are not setting a hearing date for a year or 18 months, you might have some initial settlement negotiations, but as I said earlier, where the respondent has an interest in delay, they may not be particularly interested in settling that case until they have to, which might be on the eve of hearing. So that's why some cases take longer than they should to settle. It's not for lack of interest on our part or on board staff's part. We may make an initial settlement offer and not hear anything back for 6 months on what they even think initially of that term. And we can try various gambits to get them to respond. We can say that this is, an exploding offer that will only be good for this period of time or whatever, but, that doesn't always work. Now,
There's truly no statute of limitations once you give them the offer?
there's no, the only thing that decides when that offer is still good is board staff or us deciding that that offer is going to be withdrawn. Basically, we're operating on normal civil contract principles, which means if there's offer and acceptance, you've made a contract. The disciplinary orders before the board for stipulations, those are actual just contracts that are then enforced by a petition to revoke probation. There's no sort of statutory underpinning for those other than the statute says the board can settle for anything that's not contrary to public policy. So these stipulations that you see are a contract formed initially between the respondent and the executive officer, and then once it's adopted by the board, so what we enter into initially is a contract to present those terms to the board. Then once the board adopts them, then they become a decision in order of the board. But up until that point, we can make an offer, but we have no ability to force them to either accept or decline that offer. The only leverage we have is to withdraw the offer. And an offer once made is, continues until it's either declined or accepted. So it could be a long time until they make that decision. We may want to withdraw it because we learn new facts and don't want them to have that offer anymore. We may want to, put a time limit on it. But those time limits are really hard to hold. Let's say, we have a hearing date on calendar a year from now, and we say, this offer is only good for this month. Okay, so we get to that deadline. Are we really not going to settle with that person if they come back 9 months from now and say, okay, we'll take the offer that you offered us before? Like, are we really going to hold to that? No, we're going to go to hearing and we're going to insist on spending more money to get probably the same terms that we would get by way of that settlement. So it's, they know that. They know that, there'll be more costs in the case. The usual delimiter on willingness to settle early is our willingness to be negotiable about the costs in a case, and the fact that the costs are going to be lower the earlier you settle, because the longer the case is in our office, the more time we spend on it, the more the costs increase, the more those costs are charged to the respondent in cost recovery. So that's usually the biggest incentive that people have to settle early, particularly if the board staff are willing to negotiate or discount the amount of cost recovery that's actually been spent.
I'm just worried about kind of two things. One is what we were talking about earlier, where someone's stealing like a lot of medication, or it's a pharmacy where it's there's some drugs or corresponding responsibility issue. It just seems like you'd want to close those down quicker and deal, and not have that bad actor out there. Even if we're going to put them on probation, they're out there not on probation. I think that's one of the things that always kind of worries me, is that we put them on probation and we look at it and, well, they've been out there for like 4 years, and now we're putting them on probation for something they did 4 years ago.
Well, in the most egregious cases, your staff has made a much more regular practice. This is something that Ginny and Ann really instituted, of seeking a lot more petitions for interim suspension orders. Those have not always been super enthusiastically received by my office, because those are very resource intensive, and they also sort of jump the line in terms of that case then has to be done ahead of a case that may have come in before it from another client agency. So, there's always going to be balancing acts, there's always going to be understaffing, there's always going to be those kinds of things. And like I said before, you can only file a petition for ISO if you're actually ready to bring the case. You may not want to bring the case because of a pending criminal action. There's all kinds of things that might impact it.
But with all that in consideration, like, what is the average amount of time that it settles?
Well, like I said, most cases take a year.
And that's from beginning to settlement, or is that from?
That's beginning to adjudication. And adjudication, one of the ways of adjudicating is settlement. One of the ways is an actual decision. So that's a sort of.
I was thinking the year was from case referred to accusation filed.
Oh, no. That's usually 90 days.
Okay.
Hey, Debbie, are you done?
Yes, I am. Thank you, Stan.
Okay.
It works a lot better when we're across like this.
Again, I feel like I'm in another area code over here. I'm going to start calling in my question. One of the questions in answering, I don't know if you had anything to do with putting this together, but it was very helpful. The question is, how do you reconcile taking action against a licensee when 4 or 5 years have passed since the violation occurred as people change? And so it's one thing we're talking about diversion of drugs and terrible things that we then there's the other issue about a lapse in good judgment that that a reasonably good person might have, or a mistake, or, you know, in my mind, there's different levels of gravity as far as. So the response is typically a delay in resolution of a matter is a benefit to the respondent in the matter because the delay is afforded the respondent time to show himself or herself as rehabilitated. I haven't noticed that. I've seen people who, you know, a couple of years later, where it seems to me that the consequences are the same. Is this not on? It seems to me, thank you very much. It's good to see you got a helper there, Zita. It's good to see. I just don't see it. I see a couple of young women come to mind who had lapses and years go by and they've almost got their lives back to a normal state and all of a sudden you know, there's a hearing or a settlement and they're back at square one with no consideration for any rehabilitation that has occurred. This is in my observation since the time of the crime or the infraction.
I mean, you have a wider anecdotal experience than I do because you see all the cases from all the cities. So I think you should depend on your own observation of that to the extent you want to. What I meant by that response, which is part of what I said, what I meant is, so let's say that it's been, I think this board had expressed discomfort with cases that are more than 3 years, or maybe it's 4 years, I can't remember, old by the time they get to you. And that could include, you know, a year in my office, it could include a year waiting for a criminal case, whatever, it could include a lot of things. What I meant to, what I said and what I feel is that I don't think the time lapse should be disqualifying. In other words, I don't think that the amount of time precludes you from considering the seriousness of the conduct as of the time that it occurred. Now, obviously, you as an individual are going to make, everyone's going to make a different judgment about how much that time lapse should affect what kind of discipline you think is appropriate and how much you're going to take into account what they've done in the intervening period, how much you're going to take into account the fact that, you know, they've been proceeding without further complaint for another 4 years, whatever it is. Obviously, you're going to make that calculation. All I meant to express is because you don't have a statute of limitations and because there's no viable claim of laches, I do not believe you are legally authorized, and I don't think you should say blanket, you know, a certain age of case is not applicable for discipline, because that would be essentially imposing an informal statute of limitations that's not reflected in the statutory regulations. So I think there's nothing to prevent you as an individual board member from making your own calculation about how that lapse of time is going to impact your judgment. I still believe, though, that you should start from a position of taking that offense, whatever it is, comparing it to the disciplinary guidelines, see where it ranks in terms of the discipline that's suggested by the joint authorization of the board in terms of what discipline is appropriate for which offenses, and then, you know, calculate from that. Say, you know, given that it's been 4 years and given what this person's done, do I still believe that this offense merits the discipline that's called for in the disciplinary guidelines? And if I'm going to depart downward from that, do I have a reasonable basis for doing that?
Yeah, but usually, I mean, we read the cases. We get the mail votes and we read the cases. But usually, all of that has been settled except for the mail vote. And I guess we could intervene, and there are times when we do intervene. But generally speaking, it's not us that would change, you know, stipulated settlements on a regular basis because of the passage of time. And so, you know, what impact we could have on a stipulated settlement as far unless it's just, you know, there are times when I've been disappointed with the stipulated settlements, but it's extraordinary and usually not because of the passage of time. Yet the implication here from you is that the passage of time would modulate, maybe, if that's the right use of the word, the consequences.
Right. I mean, I get secondhand what board executive staff get also secondhand, but slightly more firsthand than I do, which is looking at all the mail votes, which ones are held for discussion, which ones are immediately approved. There are cases at both ends of the spectrum. There are clearly cases that appear to have been rejected or held for discussion because the agreement doesn't seem to be harsh enough. There are those that are held because the case seems to be too harsh, and maybe that's an indicator of time lapse, maybe it's something else. So I don't think there's, and Ginny and Ann would have much better testimony to give about this than I do, and they should be cautious about how they do it because we can't discuss individual cases in public, but they are reacting to different signals that they're getting from the board on different cases. My personal experience has been that this board has been going a different direction than the previous board or the board of the last few years. The last short while, at least, it seems like this board has been verging more towards harsher expectations of what discipline will be. Now, that's just anecdotal, and Ginny or Ann could say better whether that's true. But at the same time, I've also heard from this board that you're not happy with cases that take a really long time. I don't know yet whether you've actually modulated your expectations about the discipline that applies to those people, or if you're just expressing a general dissatisfaction with timelines, separate and apart from what discipline you might impose in that particular case. I'm trying to explain to you that most of the time, there's always going to be exceptions, but most of the time, the timeline is justified by the work that's necessary. You obviously can look into individual cases, and there's going to be cases that come before you for decision where there's no good explanation for why 2 years went by without a pleading. Who knows? Maybe the DAG doesn't put that information in the letter. Maybe there is a good reason they just don't bother putting it in. For the DAGs that are on my team, I try to make sure that their letters give you an accurate depiction of the case and all the information that you would need, including things like, why has the case taken so long? But I only control my particular team in terms of what gets presented to you. So I guess my sort of short answer to you is, if you want to clearly convey that a lapse of time is unacceptable or something, the only way you can do that is by departing downward or rejecting the stipulation or whatever. That's hitting a tiny nail with a really large mallet. So I understand how unsatisfying that is, because you're not saying, I don't think you're saying in most cases, that this person should get off scot-free. You're just saying, why is this taking so long? And so using an individual case to send that message, I understand, can be very unsatisfying. The only other way you can do it is the way you are doing it, is by convening these kinds of meetings, having me come before you and make a presentation, and expressing your general preference that cases get done more quickly rather than less quickly. And I think, in terms of efficiency, I think it's a shame to lose Ginny, because I think Ginny really was focusing on efficiencies, and she's done a huge amount in terms of hiring more inspectors and really staffing up the board much more than it used to be. Cases are way faster. She's done tons of stuff in terms of getting uniformity of templates for inspection reports and for investigation reports. In terms of the way the board is functioning now, as opposed to the way it was functioning, and this is no negative comment on anyone who preceded Jenny. I'm just saying the board really is functioning fairly efficiently now. So a lot of that is because, as you know, Ginny never stops working. I'm sure all of you have also gotten the 3 a.m. email from Ginny. So, we're going to miss that energy in terms of driving things forward.
Thanks, Josh.
Sure.
I just wanted to say that I have noticed, at least in the last year, that we discussed cases a lot more than we had before. I noticed that once, before it was based on majority vote. Now, if two of us disagree, we get to actually discuss the case, and we do get to take everything into consideration. Not only we actually get to take in consideration what the person has done to rehabilitate themselves, and I think we have been doing that. But I have noticed in the last year that we actually get to discuss the cases a lot more than we were doing before.
Right, and obviously that's more work for you. That delays, you can only do so many cases in each meeting. I mean, it's just, that's a further built-in delay, but obviously if that's a value that's important to you, that's something you should do. It's always a balancing act of how much of a bottleneck are you going to be in terms of actually getting to the discipline? Is that going to be another 6 months, because it has to be scheduled for a board meeting, not even 1 out, but 2 out or whatever? Is that delay worth it? And then there's always issues. Some of these settlements are very time sensitive. One of the ones you're going to be discussing this time is very time sensitive. So, are you somehow interfering with the expectations of the parties by holding a case for discussion? There's things like that have to come into play. So it's not, there's no easy answer to what the right approach is. But one of the things I was going to say here is the final point on this slide is that we don't always get a very clear picture of why you're rejecting a stipulation. And when I say we, I mean we in the Attorney General's office, because we are not supposed to be participating in the closed session discussions. And what happens in those closed session discussions is sometimes reflected to us, but sometimes not, and most often not. So mostly what we'll know is the stipulation was rejected, they want to eliminate this term. Or the stipulation was rejected, they want to add this term. And that's typically all we know in terms of what your discussion was. So we don't know any of those factors that you may have considered, unless we were called into closed session to participate in that discussion. But as a general matter, that doesn't happen in every closed matter discussion. So so just keep that in mind, that there's a certain amount of information that we don't get. So if you really want to sort of tell DAGs that you want more information in the letter, and that's the reason you rejected the stipulation, then you need to make that clear to staff that you want that reflected back to the DAG.
Before you go on, with these stipulations that we see, is that from your office or is that from the staff? How do those originate? Some of them seem to come from the staff here.
The stipulations are always prepared by our office. There's a few minor things that are prepared by staff themselves. Things like when someone has filed an appeal and has had a statement of issues filed, staff can file, and then they decide to abandon their appeal and they don't want to continue with it. Staff can themselves file the document that follows to withdraw the statement of issues and just say, essentially their denial is affirmed. But any stipulation that's actually settling a contested case would have to be prepared by our office, because that is the practice of law. But then the terms are presented to us by board staff. Like, we don't make the decision about what to offer them. We just do the word processing to put it into the appropriate format.
And just to kind of keep it in mind that at that stage, so the executive officer is the complainant in those cases, and the deputy attorney general is the attorney for the complainant, and then obviously you have the licensee or the applicant who's the respondent. And so those parties, the complainant and the respondent, are the ones who collectively reach an agreement with their counsel to be presented to the board, who's acting like a judge.
And that's actually a really important point, because until there's a decision, our office does not represent you, the board. Our office represents the complainant, the executive officer. We are essentially the prosecutors acting at her behest to present a case before you. And the reason we can't represent you, and the reason we're kept at an arm's length from you, is to ensure the due process rights of the respondent. You are not supposed to know about the case or have any contact with me. That would be an ex parte communication if I were to speak directly to you, because the only things that are supposed to come before you are the things that were either admitted into evidence or are coincident to the stipulation that's coming before you. We're not supposed to be communicating with you prior to that, and we don't represent you until there's a decision.
Right. And that's consistent. So that's the slight differentiation between the Deputy Attorney General and Josh's role and Kelsey and my role with you. So, and one of the reasons that we're very careful in protecting you when you hear people come up to the board to not talk about specific cases is for that very reason, that we do our best to insulate you. We insulate ourselves, or we sort of know when we have to take ourselves out if we've crossed the line into getting involved in the investigative role. And so we're very cognizant of that in interactions with you about licensee and applicant matters.
And there's very complicated stuff I could tell you about all the due process protections. I won't bother you with those now, but if you want to know at some point what all the different roles are that you as an agency, the administrative state, grew up essentially since the 50s, and there's these, essentially quasi-judicial functions performed by non-judges. And so there's all kinds of protections that were built in to try to protect people who are appearing before non-judges, to give them due process protections. And one of those is that you're not allowed to know anything about the case before it comes before you.
And Kelsey and I are giving a presentation later this afternoon that's going to touch on those pieces as well.
So I mentioned earlier that once you have a case and it's filed and you have a notice of defense, and we usually try to do an initial settlement conversation before we set the case for hearing, because for a couple of reasons. One is we want to get the case done as quickly as possible, and obviously setting a hearing builds in some time. Second, there's different incentives that apply at different times. You might think that having a hearing on calendar would always provide incentive to settle. But if the hearing on calendar is not for 6 months or 12 months or 18 months, that's actually a disincentive to settle. And so we try to use the setting of a hearing as another event. Well, if we're not going to settle, I'm going to have to set this for hearing, and that actually provides an incentive for people to settle. So the other reason we don't want to set every case for hearing as soon as we get it is that would quickly clog up the courts, the Office of Administrative Hearings, with all the cases that we are pretty sure are going to settle, and the cases that we really need to take to hearing would just be that much further delayed. So we have to make judgment calls about when and how we request to set a case. So sometimes we'll get inquiries from the client about, and the clients, particularly Board of Pharmacy, are very good about saying, this case doesn't have a hearing date. Why is there no hearing date yet? And we'll say, well, I'm still waiting for this mitigation package. Can we wait another 30 days before we set a hearing? Things like that. So that there's a huge amount of back and forth in terms of the settlement process and the request to set process. Those are often interlinked and consecutive. But assuming that we do set a hearing date, the Office of Administrative Hearings has a limit saying you can't set a case more than a certain distance out. It varies by city. For Oakland, it's 150 days. Typically, it's 180 days in the other cities. So let's say that, opposing counsel gives us a date that's a year out. We're not allowed to set that date right now because they have various, mandates that they're responding to in terms of OAH, that they're not allowed to set cases out too far. So we have to essentially freeze that date on our calendar, but actually make the request to set in 6 months so that we're within the window that OAH will allow us to set cases. So these are the kinds of things that we're dealing with in terms of juggling cases. We have to figure out how much time we need for the case, whether it's a 1-day case, a 2-day case, a 3-day case. We have to make sure our witnesses are available on the date that we've selected with opposing counsel. There's a lot of juggling that has to go on with that. Sometimes the case could be venued in a different location. Trial setting conferences are not that common. I mentioned earlier that a trial setting conference is sometimes a tool that we use to bring a particularly obstreperous counsel to heel a little bit in terms of giving us a date. If they're either refusing to give us a date or just not responding or giving us a date that's just ridiculous, we will bring them before OAH to bang on them a little bit and try to get a date out of them or get a more reasonable date out of them. Again, that's not a bullet that you want to use too often, because if you bring every case for a trial setting conference, pretty soon we're going to be the ones being beat on as opposed to opposing counsel. So we have to be judicious about how we make use of that tool. Once we set a date, we send a notice of hearing that tells the other side. It has to be a certain distance between when the notice of hearing is served and the date, so we have to make sure to serve it soon enough. Sometimes there's a pre-hearing and a settlement conference. Those are only automatic in cases that are 4 days or more. We don't set them in very many cases because our experience has been that Settlement conferences only make a marginal difference in terms of the likelihood of settlement, and they can be an expense. But we do make use of that tool when it seems appropriate. And then we're ready to get to the trial. So assuming that settlement has not been fruitful, we have to start gathering all of our, this is phase 3 in that original infographic that I gave you. This is where we do all of the stuff that's necessary for trial, including preparing our witnesses, which can be a time-consuming process in terms of telling them what questions you actually might ask them, seeing how they respond to those questions, seeing if you want to change the questions you ask them to respond to how they responded, things like that. You have to make sure that you're solid on all of what you thought was originally a good case. Do you still think it's a good case by the time you're ready to go to trial? Are you going to keep all of the causes for discipline? You prepare for anticipated defenses, either ones that have been stated or ones that you can anticipate from the evidence. There are lots of pretrial discovery things. If, as I mentioned earlier, quite often we don't get the discovery to which we're entitled from respondents or respondents' counsel. So we have to make a judgment call about whether it's worth trying to compel that production, whether it's worth issuing subpoenas to third parties to try to get the records if we don't get them from the respondent, things like that. So there's some amount of investigative work that our office does to try to supplement documents or other materials that the board was not able to gather. And then there's the hearing. So as I said, if they don't return a notice of defense, that's one way that we could issue a default. If we've issued them a notice of hearing and then they don't show up for the hearing, that's another way we can issue them a default. And that's the only way to issue a default in a statement of issues case, because there is no notice of defense requirement for a statement of issues case. So the only way, if you have someone who has a statement of issues pending against them and then they drop off the map, which happens all the time, the only way to get that case out of our office is to schedule it for a hearing that you know they're not going to show up to, and go through the rigmarole of sitting there for a while to show that they're not showing up, having the judge make a finding that they're not showing up, taking the case back to our office, and then doing the default. So there's, as I was saying to someone earlier, dictatorships are much more efficient. If all these things of giving people rights mean that there's certain things you have to go through, and that's the nature of a democracy. We have to, and one that's concerned with due process. So these things take time. At the hearing itself, you put in all the documents in the testimony. This board was pioneering many years ago. I think this was still under Patty 15 years ago in trying to save costs and increase efficiencies by having most of Board of Pharmacy cases are electronically recorded as opposed to having a court reporter, because that's a lower upfront costs. It may slightly increase the back-end cost because
what happens when you talk too long. Because so few cases result in an actual transcript, the decision was made, and I think it's been borne out. I mean, Jenny or Ann or Susan could probably tell you. I think the quality of a transcript might be slightly less from an electronic recording. I don't know. That's what someone told me. I've never had that experience, so I don't know. But the point is, it's a little bit less expensive. The proceedings can go a little bit faster because you're not having to go at the speed that a court reporter can handle, things like that. All right, so this is the most sort of interesting legal part of it, which is the standard of proof. So there are different burdens of proof depending on what kind of case it is and what kind of respondent it is. There are two factors. So first of all, in accusation cases, in disciplinary cases, the burden of proof for a pharmacist or anyone else who's deemed a professional to have a professional license, and typically what professional means is that there's a degree of some, like a university degree associated with that license. That burden of proof is clear and convincing evidence to a reasonable certainty. Now, your guess is as good as mine exactly what clear and convincing evidence to a reasonable certainty means. We know that it's more than preponderance of the evidence, and we know that it's less than beyond a reasonable doubt. I think most people estimate it at like 75 to 80%, but who knows? But anyway, that's the standard for an accusation case against a pharmacist. For what's called a vocational license, which is not associated with a professional degree, which would include pharmacies, pharmacy technicians, wholesalers, designated reps, any of those other license categories. In an accusation case, that is only a preponderance of the evidence standard, which is usually considered to be 50% plus 1. So that's just barely a majority. Now, in citation cases or any case that's non-disciplinary, the standard of proof is also preponderance of the evidence. So those are the basic rundown of the standard burdens of proof. It's also preponderance of the evidence in a petition to revoke case, which may be counterintuitive because that is a case that's ultimately imposing discipline. But in that case, you're essentially just enforcing the contract of what the person agreed to or had imposed on them by decision. So that's considered to only be preponderance of the evidence. You're not reimposing discipline. You're essentially just enforcing the discipline that was already imposed. An ISO is also preponderance of the evidence. There's no clear burden of proof for a PC-23 in a criminal case, but it's essentially probably a similar to preponderance or maybe even a probable cause standard, which is a little bit lower than preponderance. Any questions about burdens of proof?
I'm sorry. I'm a pharmacist, not a lawyer. So just give me like an accusation versus a statement of issue. Just give me an example of each one of those.
An accusation is where you've done something wrong and you're a current licensee,
Okay.
and case is being brought against your current license. A statement of issues is where you're not yet a licensee. You've applied to be a licensee and your license application has been denied and you've appealed that denial. The statement of issues is the pleading that's issued to explain to you the reasons for the denial. And then that's the basis for the hearing if a hearing goes forward or the settlement if the settlement goes forward.
So it could be the same issue. It's just whether you're actually a licensee or not.
Right. And it's important. I'm glad you asked that question because whereas in all these other cases I'm mentioning, accusation, citation, petition to revoke, the burden of proof is on the complainant, our client, the executive officer. In a statement of issues case, because it's someone seeking a license, it's their burden of proof. And it's not clear what their burden of proof is, but it is probably preponderance of the evidence that they have to show that they are qualified for and fit for licensure, even notwithstanding whatever the reasons for the denial were. They either have to disprove those reasons or show that notwithstanding those reasons, they should still be licensed. So lots of things can happen in the run-up to a hearing or immediately before the hearing. There are what called motions in limine. These are motions that are filed by attorneys typically or by parties to limit the scope of the evidence. Sometimes you stipulate to certain evidence, or sometimes you file a motion to say, that expert is not actually qualified to testify in this case. That person should not be allowed to testify, or they should be limited in what they can testify to, or those documents were collected without a notice to consumer and violated someone's privacy rights, so those documents should not be allowed in. There's all kinds of reasons that you might seek to exclude or limit evidence, and the way you would do that is by a motion in limine. They're not super common in our cases because most often the facts are pretty well established and there's not that much dispute about the facts, but we do occasionally file motions in limine to exclude expert witnesses on the other side. If, for instance, we have a psychologist testifying about the psychology of drug diversion or something in some way that we don't think is an established science or doesn't seem to be actually providing a defense, we might file a motion in limine about that. Anyway, all of this I think is self-explanatory, but this is all the kinds of things that we're considering in terms of preparing our evidence for hearing and how we're going to present it at hearing. And then this is what happens once you get the case. Either you have a proposed decision. This is if when a case has actually gone to a hearing. This is not by stipulation. Stipulation obviously skips all of these steps. This is a proposed decision comes to you. The decision is due to you within 30 days after the hearing. That's not an enforceable requirement. In other words, if it's more than 30 days, nothing particularly happens. But I know that the ALJs really do endeavor to meet that 30-day deadline, and my experience has been that they almost always do. Once you receive the case, the board has 100 days to act on the case. If you do nothing within those 100 days, it's automatically adopted. So if you want to decline it or modify it, you have to do that within 100 days.
And then there's always all kinds of options. There's things you can do without adopting or non-adopting. You can make just technical changes, or you can reduce the penalty. Those are both things you can do without formally non-adopting it, just by modifying it. And then once the case is, final, then the way that a case is appealed, a way that a respondent would appeal your decision, is by filing what's called a petition for writ of administrative mandate, or mandamus, in a superior court. So there's no automatic right of appeal. They have to file an affirmative, essentially a civil case. It's actually an equitable case, but essentially a case they have to pay filing fees unless they're waived. They have to go to superior court to seek review, judicial review of your case, of your decision. So I've summarized a lot of these already, but the greatest contributors to delay, typically, in my experience, at the investigative stage, are criminal cases, co-investigations that may or may not be criminal. For instance, we're often involved in fraud cases, and sometimes the Bureau of Medi-Cal Fraud and Elder Abuse is brought in. They have simultaneous criminal and civil jurisdiction, so you don't always know whether they're investigating something as a criminal case or a civil case. There's often, FBI or DEA or even ATF. Those kinds of alphabet agencies may be involved in investigating the case. Sometimes we get cooperation from them, sometimes we don't, sometimes they share with us, sometimes they don't, so every case is different. At the pleading stage, pharmacy cases tend to be more complex than other cases, which has two effects. One, it takes a little longer to plead them, and two, not all DAGs are super enthusiastic about getting pharmacy cases. So you may have a smaller pool of people in each city, and not that DAGs get to choose their own cases, but there's some discretion given to people to, reject certain clients or whatever. So you may have a smaller pool because these are, they're brain cases. They're not the easiest cases in the world. Settlement stage, as I said, all kinds of delays getting information from the opposing side. They're responding to the settlement terms we may have made. They're being willing to calendar a case. Then even if they calendar a case, quite often what happens is a respondent will change counsel. The substitution of counsel is not supposed to be good cause for a continuance, but quite often it is. Usually my experience has been that a respondent gets their first continuance request, even if the reason is not particularly good. And then the second one, they hold them to the reasons. So that can cause some further delay. And then witness availability. Sometimes, our inspectors are testifying and have many cases, so sometimes they're not available on either the original date or a new date. And then at the decision stage, there's the delay built in by the board holding the case for discussion, by someone filing a petition for reconsideration, by a default being set aside in favor of re-prosecuting the case. So there's all kinds of things that can happen at that point. That's it. I'm finally done.
Well, I guess you understand that this board's been really frustrated with some of the delays, and so if there's any effort that you could help to expedite some of these process or anything you think we could help to speed up some of the process is highly appreciated.
Yeah, I mean, one of the reasons that my boss, Linda Schneider, the senior assistant of my office, of my section, met with Ginny a few months ago, and she's willing to come present to the board if you wanted to see those stats yourself, is to emphasize how much this is important to us. And not just because it's independently important to us, but now there was a statute passed a couple of years ago that kind of as a way of putting pressure on the individual boards and bureaus has sort of come at it through our office and is requiring our office to report timelines of how long cases are taking of various types and various whatever. So in order to meet those reporting requirements, we are generating huge amounts of data. That's somewhat slowing down our prosecuting of our cases because we have to, do a lot of reporting, but it's also creating real hard deadlines for us. So in some ways it's expediting our cases. But the upshot of that is we have a lot of data. We are generating these reports to the legislature every quarter. And Ginny has already seen the data from not this most recent report, I think, but the one prior to that.
And so that's data that's freely available. You can see the reports either through the legislature or through us. We can present on them. But the upshot is we are staffing up in all of our cities, really trying to get cases done more quickly. I'm not honestly sure that under a year is consistently possible. Maybe 9 months to 10 months could be a sort of average time in, time out. Anything less than that, I think, would be very difficult just because of the delays over which we have no control, whether it's calendaring at OAH or opposing counsel or delays in co-investigations, all those kinds of things. I don't know. But yes, I definitely have heard many times now how much the board wants these cases expedited, and we're going to do everything we can.
Yeah, thank you. Any other comments from board members?
Well, I think, when you look at the cases, I mean, part of it is when the cases are referred to the AG and then, when it's adjudicated. But there's also a delay from the point where the complaint is initiated to the AG, and sometimes that tends to be 1, 2, or 3 years in itself. And I think that's part of the frustration too. So I think
All frustrated with delays.
The only comment that I would have, and I'm sure all your other clients would say the same, but this board is very, very lucky to have Josh as somebody who can lead us and with these legal issues, because your expertise, I'm sure, is second to none. So thank
Well,
you.
every time Ginny calls me, or not every time, but almost every time that she answers, I call her or she calls me, she says, it's your favorite client. And she's not wrong about that. So, I mean, to the extent that I'm responsible for it, I make sure that pharmacy cases from my office receive priority. I don't control the whole state, but that's what I'm responsible for. Thank you, Stan.
Thank you very much, Josh. Okay. With that, any public comments? Okay. Please come up.
I was trying to give it away, sorry.
I guess my question for Josh is that since the case starts all the way till it's signed by the Board of Pharmacy, why isn't it that the pharmacist being charged never gets a chance to speak with a qualified pharmacist, office visit, even, there's no office visit, and even with you, why couldn't I possibly be involved in the settlement before we go through all these hearings?
Well, there's a number of reasons for that. First of all, I would dispute your characterization. In almost every case I've ever seen, as part of the investigation, the respondent, the pharmacy or pharmacist, is given a notice of violation to which they can respond in the initial investigation. They are interviewed or given an opportunity for an interview. So there may be individual variations, but that's certainly the expectation. Now, beyond that, we cannot engage in settlements without a publicly filed document. That's just the way the APA is written. We have to have, this has to be done in public. There has to be an underlying accusatory pleading, so we are not allowed to negotiate a settlement without going through the pleading and filing process. So, and that, that could be changed by statute, but the reason that that's done is ostensibly, at least, to protect the rights of respondents, because they do not want, and to protect the public, they do not want private settlements that no one has notice of, and they do not want respondents sort of bullied into accepting terms by the threat of prosecution. So those are the reasons that has to be done in public and only pursuant to a public filing. Now, if you've had an individual experience about not being interviewed or given an opportunity to respond, I don't think this is the right forum for you to discuss that right now. But I will say that the expectation is that in every case I've ever seen, in every training I've ever given to inspectors, is, we want that interview as much as possible. I mean, there's certain cases where it's not worth investing in an interview, particularly if the person is represented and counsel, it's clear that counsel is not going to really let that person be interviewed. There may be no point in investing the resources in doing that interview. But typically, as a prosecutor, I really want that information from what the respondent may have said. And I'll be honest with you, most of the time it's because that person makes admissions. They may not admit everything, but they will admit some portion of it. So it's to our benefit, to the board's benefit, to do that interview. So I do not think that there's any kind of strategy reason for not doing an interview.
It would seem like if I could have spoke with you, we would stop all this. I'm not sure if everybody's aware of this, but once they take this to this hearing, which is settlement, you're looking at dropping minimum of about $70,000 to $80,000. You have to hire lawyers, and then doesn't matter what happens one way or the other. I'm not sure if you're aware of this, but the plaintiff has to pay for all the bills of the legal bills. So why not try to end this and correct this right at your level? Actually, if I wish there was an office hearing. I'm sorry to say I did not have an office hearing. And if I could have talked to a pharmacist who is qualified, it would have been settled. I didn't have to go to these hearings, spend hundreds of thousands of dollars. And I think that he would like to have listened at a hearing with, right then and there with the pharmacist. I think we could have settled right then and there. But to go to this hearing and to go through all this expense, and that's just the pre-hearing. Then you got to go to a trial. You could be looking at dropping another $100,000. So it's really important. I understand criminal charges. I understand bad things. But administrative violations, I don't know. I'm just sorry. That there's got to be a better way. I really hope that no one ever goes through what I did.
All right, thank you for your comment. Before we go into the enforcement committee, shall we take another 5 minutes break? Okay, let's take 5 and we'll come back. All right.
I'm proud to say I'm a 2-break presenter.
The next item on the agenda is the report from the Enforcement and Compounding Committee. Okay, Chairperson Allen.
Okay, mine's just a little bit longer than Josh's, but I think we'll get through it.
We're gonna take 3 breaks in
I was gonna
between.
say,
I want to beat Josh here. Yeah, I've got 8 items, 4 motions, and 3 attachments. So it's something to look forward to. Okay, number 1, discussion and consideration of.
Are you finished?
Almost. Possible board policy relating to transparency involving the issuance of citations and fines. Background. During the 2018 Enforcement Committee meeting, the committee requested that the board staff survey all DCA Healing Arts boards to determine how each of the boards handles the general transparency related to the issuance of citations and fines. The committee was advised that the Healing Art boards were surveyed to determine which board posted citations and fines issued to the licensees. The survey showed that 15 of the 18 boards posted citations and fines on their website. However, the duration varied. It should be noted that most boards surveyed are actively using the Breeze system, which may be programmed to upload citations and fines to their respective sites. Does that imply that our system won't easily do that?
The sample that we gave is from the chiropractor board that is also not on Breeze.
Oh, okay.
So we chose that one as the sample so you would see.
Okay. We have a summary chart, which I'm sure you all printed out, and that lists the variety of boards, how the fines are posted, and how long they are posted, and if they're a Breeze participant.
So can I ask?
You can.
Can I ask, where's our pharmacy board?
Our pharmacy board's not on there because we don't
We don't post.
That's the issue. Weren't
Got
you
it.
paying attention?
Well, I actually went back and, I'm trying to stretch this out for you so you can
thank
get
you.
the 3 breaks.
Okay.
But then also, I went back and read, I didn't quite understand that that's what the purpose was, but thank you.
Okay. So, the committee recommended and made a motion that we move forward to direct staff to identify possible parameters on posting mechanisms and conditions under which the citations and fines would be posted, and we came up with 3 years for time.
So I have another question.
Go ahead.
Is this
Now
one
you know why
relevant?
Stan's way over there. I was thinking that cite and fine, were we considering those not punishment?
They are not disciplined.
Discipline, yes. And so that's why we had decided not to post them?
Right, they're still public documents and they're available upon request, but we didn't put them on the website because we thought that they might be misunderstood by the public, frankly.
So can you fill me in on the discussion at the committee level, why the committee, I understand transparency, I did read that the committee felt like it was appropriate to go ahead and display them, but is the committee not worried about what Jenny just said about the public not understanding?
Well, there was discussion among the board members and from the public. And since the other boards, the health boards, do list them, it seemed like it would only be fair for us to do it also. It also was thought that since the board members themselves might be have fines against them, it wouldn't be so secretive, you know. It just seemed like transparency is such an issue now that we should go ahead and do that. Now, there was public comment that, you know, that it might have the public not trust pharmacists so much, but then why shouldn't they know what errors are occurring out there? You know, the public, and essentially, has a right to be aware of that. Yes, please.
One of the other things was that there was quite a bit of talk about the fact that board members themselves don't know about citations, and there's a perception that board members are involved in the citation process, and this was one other way that members might be aware of citations that are issued.
So would it explain what the citation or fine was for? Like, would it say,
If you'll see Appendix 1,
thank you.
which I would hope, the chiropractic board is the example that's given, and hopefully our board would be able to explain them in a little more detail. I think this would give also members of the pharmacy profession insight into what is being looked at and what fines are being assessed for these items. It's a step towards the transparency of what the board is doing. No one knows essentially what is being fined, what actions those are. They're too nebulously described in the script, although that has gotten a lot better. And so I think it would be better for the profession, and if they're aware of what the inspectors are looking at, what their colleagues are doing, it would lead to further public protection.
So is this the medical boards doing it also?
Yes. As a matter of fact, I looked up a couple. Pretty interesting. Yeah.
And is the medical, so we call it cite and fine, and I look on here, and it just says citation, so it does not list the fine?
Oh, you know, it does not list the fine on there, but I think that would be interesting, too.
I mean, I think in transparency, just in what we were just talking about.
Oh, Josh is out there.
Yeah, but Debbie's not finished talking, so.
No, I was just saying,
Quick learner.
in kind of, in that consistency conversation we had, it seems like listing fines, I mean, if we're gonna be transparent, then maybe listing fines is something we should include.
Right, so all of these are good and valid reasons. I just want to make the board aware, as I think I did at the committee meeting, that this is going to result in far more litigation of citations. There's going to be a lot fewer settlements of citations or acceptance of citations, because people are going to perceive now that this is going to be something that's on their record in a way that's more available to the public, and they're going to feel the need to contest it. Nowadays, a citation, although it is a public record, you have to know the person's name in order to request it. You have to go through some effort to get it. If that's freely available by way of just looking them up on the website, citations become a much bigger deal. And I know this personally because citations for the CSLB are a much bigger deal than citations for the Board of Pharmacy because Contractor State License Board has made them public for many, many years. And people feel like even a citation, even though it's non-disciplinary, and that's a little bit different because you tend to look up your contractor before you hire them, so obviously that could be a death knell to their employability. But still, as you know, those of you who are pharmacists are very detail-oriented, exacting people, and I think that there's a natural tendency to believe that they're doing things correctly and not accept that they have done things incorrectly. And up to now, I feel like one of the biggest motivators for settlement of a citation has been that keeps it from becoming as public as it otherwise would, because if you litigate it and it becomes a decision of the board, that's more likely to be made public. Secondly, I think people are more willing now to say, I don't really think I did that, but it's not worth it to me to litigate it. It's not worth it to me to expend that money. I'm just going to go ahead and pay it, or I'm going to go ahead and pay a reduced amount or whatever. I think if people feel like this is going on their record in a way that's searchable by everybody, they're going to be a lot more likely to litigate those cases. That doesn't mean you shouldn't do it. I'm not saying you shouldn't do it. I'm just saying it's just something you should consider is this is going to make those cases take longer, which is in turn going to increase the amount of resources that have to be expended on them, which is in turn going to affect the timelines on your disciplinary cases.
Because of the fact of what you've been mentioning, I think that if we go ahead and do it, we should not implement it for a period of time so that people understand that we're going to be doing it, which gives them the right to litigate it if they want to.
No, I'm saying that once a citation is issued, once people know that a citation is a searchable document, regardless of whether they were given notice of that ahead of time, they're going to have a much greater incentive to litigate that case.
I understand that, but
Okay.
what I'm saying is because of the fact that it's important and people would do something differently, we can't just go ahead and say, okay, from this date forward, we're going to publish it. We would have to state somehow, let the public know, let the pharmacists know that we intend to do this at some date in the future. So should they receive a citation on a go-forward basis, they have that knowledge when they decide what to do about it.
Right, and that's a really good point retrospectively too, because people may have agreed to accept a citation or
Right.
settled a citation based on their understanding that that citation was not going to be made public or at least,
Exactly.
affirmatively public. Yeah.
Oh, yeah.
I also think that if we're going to do this, one of the things we'll have to do is to make the issuance of a citation kind of a draft initially, which means changing the regulations.
Kind of
Because making it a draft to give them appeal time up front, because otherwise what we do now is this is a case closure for us. That we receive a consumer complaint, we identify violations, but they're not worthy of doing formal discipline against a license, so we do this lower level sanction. We advise the complainant, who's the consumer that filed the complaint, what the outcome was. So that's part of the rest of the citation process that we don't talk about. So the individual that triggered the complaint in the first place does get advised of the outcome. But if the board is going to intend to allow the licensee to review that you will be subject to a citation unless you respond, we're going to have to go back, amend the reg, and build that into the process.
And there's also, the decision is not solely whether to make citation and fines posted or whether to post them. The board's also going to have to decide when to post them. Do you post them at issuance? In which case, there may be additional evidence later that would, mitigate that, and maybe you will regret the decision to post it at issuance. Do you post it only when it's been either accepted or resolved or not appealed in some way? Do you post it only when it's actually been substantiated by a hearing? There's all kinds of different decisions that you would need to make about when you would post it.
Well, I just even look at the example in here, and so it kind of brings a couple ideas to me. One is, so two of the citations are failure to file current address and failure to display license. And I'm thinking, really? Then the third one is unlicensed individual illegal practice. So, okay, that one kind of would have me upset. But then if you also look at the timeline, according to this, they paid the citation in full on May 16th, but the citation wasn't issued until May 30th, and compliance was obtained on May 17th. So they actually paid before they were compliant, and the citation was even issued. I mean, I'm kind of worried. I'm going back to, Jenny, what you said in the very beginning. It's going to create a lot of questions, and people aren't going to quite understand what they got here.
Sorry, you mic'd me and I didn't see it. But part of the
No,
concern is,
I anticipate by your last board meeting, you'll actually keep it on the whole time.
there's money to be made on a bet out there, folks.
Yeah.
Two mindsets here. We are a consumer protection agency. This is public information. It ought to be made public and put out there. The other side of that is that we are addressing minor violations early before they become significant in some cases, or before they're just not worthy, like you say, an address change or something that never got made. It gives us a tool to get compliance with a little bit of an edge, but it's between us, the complainant, and the licensee. And if you make that available, we get public records requests, for example, on med errors, and so we pull up the codes we cite med errors for. The violations are released that way. So a reporter or a consumer that wants to see where the med errors have been observed and cited for can do that by getting the citations, because the citations we produce identify the name, the address of the licensee, the violation, and then the amount if there's a fine involved.
What kind of consumer protection is it when it's failure to file current address or failure to display license? Where is the violation of consumer protection that we are here to promote?
Well, I will say that in those two examples, they're pretty minor. In the case of a failure to give the name of the license, I actually, in the last 2 weeks, I have actually had one and right before that, probably in the last 30 days, I've had 2 complaints where someone was mad that literally they were having some kind of incident with the pharmacy. They wanted to know what the pharmacist's name and license number was, and the individual walked around like this over the name tag. And so there would be an example where a citation may be appropriate because it wasn't acting professionalism. The patient probably wasn't harmed by that, but it was inappropriate behavior for a pharmacist, given that we expect you to identify yourself as a professional so that the patient knows who they're dealing with. And so again, that's an educational moment for us. We move on. It's not going to be a revocation, so it gives us a tool. Otherwise, we're not going to do anything. We're going to walk in and investigate and walk away.
I was just going to say that the analogy that I've most often given for citations and fines is that they're essentially the equivalent of a moving violation ticket. That, it's not, or maybe one that's not a point on your license. Like it's to memorialize the misconduct, to address it with an appropriate fine, to not make it a disciplinary matter. I think if you are making these searchable, that analogy is no longer appropriate, because it would be the same as if anyone could type your name into the web and find out all the moving violations you've gotten. So that's just something to think about in terms of what level of seriousness do you want to give to citations and fines. And if you take away citation and fines as a way of addressing relatively minor conduct because people are just going to take them more seriously, then you have no way of addressing relatively minor conduct except by way of a disciplinary matter or not addressing it at all. So it's possibly limiting a tool that the board staff currently use to address relatively minor conduct.
Turn it on, I think.
Is there some way that we as a board can know what those are and they not be, put on a site just so that the board knows, because we don't know what these citations are. We don't get to see that. So I'm thinking, how about letting us at least see those, and they not necessarily be published?
And we can do that, all you have to do is ask.
Okay.
What
That- is
is,
that
what
simple.
is it that's in the script?
In the script, it's formal discipline where we are seeking to remove or restrict your license. That is serious, and that is a whole different level. The script does not contain citations and
No,
fines.
no. Okay. You know, Lavonda, I think that's an excellent halfway step. And, you know, rather than, even though, what the motion is, to recommend that the committee move forward to direct staff to identify possible parameters on the posting mechanisms and conditions, which is not to do it, it's just to move forward on it. And I think in moving forward on it, inclusion of your idea would be a good idea. I mean, it's information to us to consider.
Yeah.
I mean, as a public protection agency, I would not want to be accused of saying we're hiding information. And, you know, and that's what lack of transparency is. The fact that Josh and Jenny say that it's a tool to prevent undue focus on minor, undue focuses and focus on minor citations and to be used as a tool for brevity or for efficiency are certainly to be considered. And so, I think this is good discussion, oh, Albert, go ahead.
Alan, I think, I always believe that, learn from other people's mistake. So I think if we could put on the newsletter the common citation and fine without the name and address, maybe it's a little more educational, more informational to all the other licensees, so they can learn from other people's mistakes, so they will not commit it themselves.
Well, but I'm not quite,
Oh, go ahead.
what does that have to do with the consumer? I mean, I understand limiting information on the script, but we're talking about me failing to file my current address. So I've moved from 237 Grandview Drive to 251
It's
Cajon
out.
Street.
It's out now. Go ahead.
Yeah, but that
So-
was
so-
just,
So I've moved, and, you know, I've taken care of everything, you move. And so on my current license, it doesn't have my current address, I guess.
Well, I will tell you that that particular offense is a problem for us because we need a viable license or address for you when we cite and fine you, when we
Oh,
file formal charges against you.
I
So
don't think that, I think that's, Stan's point is, this is something that's
a
not public
consumer-
protection.
Right, and
Right.
there's one that isn't
And that's
public.
that's exactly my
that's one
point.
that
But that's
isn't.
dinging, but that's
But there's
dinging
a
you for
third one that
failure to.
is.
No, but what I'm hearing is that I didn't file my address change along with the other, 80 different places I had to file it. And now it's an indication of I might be, doing something yet worse than that. And this is something that is going to, stop me from doing something worse.
What about, what about
I
the
hope not.
pharmacy contracts? Because I know they look on there for discipline. You don't think that they would,
Well, they might.
But again, you have to put into context the violation. Someone that is going to make a business decision on whether they're going to do business with you, for example, on whether or not you file an address change or not, I don't know. I mean, if that's all that's out there, I hope consumers aren't necessarily going to be influenced by that. But if you find out that a particular pharmacy has 2 or 3 med airs, that's a little different.
But if
So-
a pharmacy has 2 or 3 citations,
Let them, they can request them, they say, I want to know what Stan's Pharmacy's been cited for.
well, I go with, I think, Alan and Cheryl, that I think step one is that we don't post it, but that we share it with the enforcement committee. And have, you guys look at it and see,
I think that's a good idea.
what do we, and maybe then you also report it out in your committee report out, when you, whatever you're doing now.
Whatever we're doing now.
Yeah.
Okay, well,
Yeah,
so, well, the committee,
Yeah, I think that's a great idea because,
Well, it was yours.
well, well, that's not why, but I was also about to say what Albert had to say was also a great idea, simply because what the whole thing about posting it is just to let other pharmacists see what people are getting cited and fined for as an educational thing, but not actually putting people's names to that, but us as a board. I'd like to know what citations are being given to pharmacists and how much they're being charged for those fines, and why, in some cases, I may say, well, why so much?
You're kinda
Under these
nosy, aren't you?
circumstances. Huh? But I'm just saying that, so that we get to see them at least, just like we look at everything else. I don't get to see that, so it'd be nice to be able to see that. But I think keeping it away from Breeze.
So here's my
Well, we're not-
question. Oh,
with
sorry, go ahead, Jenny.
Alberts.
We're not part of Breeze, so that there's little risk of that happening.
But I'm talking about the script. I'm
Right.
sorry.
Oh, okay.
That's what I meant.
But one of the things we were looking at doing anyway, President Law asked that I give him a list of particular changes that we could do to improve public protection. One of them is to take maybe the top 3 or 5 citations and fines categories and describe them a little bit in the newsletter so that they see what's going on, because that way we're taking what's going on over here and then taking it back out here. And to be really full about, refueling the system, that would be the best way to deal with it. It wouldn't identify people by individual, but the top 3 violations maybe are bad address changes, failure to file an address change. All right, here's how you do it. You must be confused about how to do it. Here's how you do it. So we solve the problem that way, and we move on.
Well, there's still quite a bit of discussion here, so why don't we table this? Can we table this and move on and then discuss at the enforcement committee again?
I just wanted to ask, can I just, before you do that, Alan, ask one clarifying question on behalf of staff, which is, for the data that's going to be given to the enforcement committee, or maybe you're tabling that request too? Or you're
Oh,
gonna-
no,
Oh.
we want that data,
So,
definitely.
do you want that just in the form, I assume you only want that in the form of data that's anonymized. You don't want to see the actual citations or know the names that are associated with the actual.
Give them the citations.
But if you give them the actual citations, then those are going to become public in the sense of being included in a board
Well,
packet,
we
so
can
I don't know
redact
if you
the
want to
name
do
of
that.
that.
Oh,
would help.
no, we don't want that, absolutely.
So then I think you probably
All right,
want
we'll summarize.
just reporting of summaries and so forth. Okay.
Right,
Right.
right, so how do we memorialize that in the minutes?
I think we just did.
Direct
All right,
it. Yeah,
great.
you just direct it.
Oh,
That's all
okay.
you have to do.
So,
Okay.
I guess
That
we'll
was
move on.
easy enough.
Yeah, no problem. Thank you, Sam. All right, number 2, consideration and discussion of laws and regulations related to petitions for reduction of penalty of discipline licenses. Code 4309 establishes conditions under which an individual may petition the board for reinstatement of license that has been revoked or suspended. It establishes conditions under which a licensee may petition the board for modification to a penalty, including modifications to probation or early termination of probation. This section further specifies the timeframes that must be satisfied. Number 1 is at least 3 years for the reinstatement of a revoked license, at least 2 years for early termination of probation of 3 years or more, and at least 1 year for modification of a condition or reinstatement of a license revoked for mental or physical illness, or termination of the probation of less than 3 years. This section also provides that a petition cannot be considered while the individual is under sentence for criminal offense, including any period which the individual is on court-imposed probation or parole. In addition, a petition cannot be considered if there are additional accusations or a petition to revoke probation pending with the board. In recent years, the board has considered such petitions as specially convened board meetings where the primary focus of the agenda is the consideration of such petitions. Although the law allows for different adjudication processes, the board's policy in this area is to convene these petition matters as part of the board meeting whenever possible, and to have hearing presided over by an administrative law judge, ALJ, following the hearings. Following the hearings, board members may meet in closed session with the ALJ to deliberate on the matters presented. Once the board makes its determination, the ALJ drafts the decision on behalf of the board. In the event of a quorum of the board cannot be achieved, the board's policy allows for petitions to be heard by committee of the board, and the ALJ will draft a proposed decision and it'll be considered by mail as part of the mail vote process. Under the law, a third option also exists where petitions are considered by an ALJ independent of the board. In such cases, the ALJ renders a proposed decision which is considered by all members as part of the mail vote process. In all three scenarios, the respondent provides a packet of information of supporting materials intended to provide the board with information in advance of the hearing, and the information includes personal information and license history, letters of recommendations from board licensees, letters of recommendation from citizens, and completed continuing education. The respondent is also afforded the opportunity to provide oral testimony under oath. In addition to the respondent's testimony, a representative from the AG's office is present and represents the people of California, as Josh has pointed out. The AG office is allowed to question the respondent as well as any witnesses. Although not done in all cases, the AG's office may offer a recommendation to the board on the outcome of the petition. Technically, the board does not have representation of in these petitions, and typically the board staff does not offer testimony. Since July 1, 2015, the board has considered 41 petitions, including 26 petitions for early termination, 2 petitions for modification of penalty, and 13 license reinstatements. All decisions are not final, but of those we have that have been rendered, 13 have been approved and 17 have been denied. There in attachment 2, there's more details about these statistics. And so for committee discussion, the chair stated that as provided in law, the law may consider other factors including, but not limited to, the following: all activities of the petitioner since disciplinary action was taken, the offense for which the petitioner was disciplined, and the petitioner activities during the time the license was in good standing, as well as the petitioner's documented rehab efforts. The petitioner's general reputation for both truth and professional ability is also to be considered. To assist in the collection of the relevant information and to provide guidance to potential petitioners, the board has developed petition packets that detail both the required and supplemental materials sought from the petitioners and some FAQs about the process. The chair stated that the criteria established in the law is very general, and some questions were offered to the committee for consideration, including, is the current process for hearing petition sufficient, or should the board reevaluate its policy? Number 2, would it be helpful to have board staff testify regarding compliance with the terms and conditions of probation, the rehabilitative efforts demonstrated by the respondent, and public protection concerns? Would it be helpful to request additional information in advance of the hearing from the petitioner to aid the board in making a decision? And does the board wish to establish additional parameters that the petitioner must satisfy prior to being eligible to petition the board? Should the time frame be established that provides clarity on how long a petitioner has to satisfy the requirements set by the board, such as pass the NAPLEX, pass the CPJE, or pay fines, etc.? Part of the discussion, the staff was directed to release a petition to members at least 10 days in advance of the meeting. Further, the committee requested that question 15 on the petition be rephrased, and that question is, have you ever had disciplinary action taken against your license in this state or any other? And I don't remember how that was to be rephrased.
I don't remember, and me, but
Right,
She
and
picked a good time to leave,
It
didn't
was
she?
going to be something like apart from this discipline.
Oh,
Like, that
apart
was
from
the
this
confusion.
discipline, because
Everyone
there was
answers
confusion
yes.
in the past where they answered incorrectly, okay.
Yeah, I don't think we had exact
That-
wording, but that was the intent.
Okay, good. Okay, the staff also sought guidance from the committee about its interest in amending the statute to include a time frame for which the provisions of a license reinstatement must be satisfied. The committee is offering the recommendation provided below. The motion is to direct board staff to develop a statutory language to establish a requirement for a one-year deadline to complete requirements for reinstatement. In response to staff concerns about lack of guidance on the prioritization of petitions to be heard, the committee is offering a recommendation to allow staff flexibility to consider a petitioner's current compliance status as one of the criteria to determine if a petitioner's request should be considered. And the next motion is to authorize board staff to identify ways to prioritize these probationers that are compliant. So both of these motions are concerned with further defining
Process.
yeah,
Process.
the processes.
So, I was at this meeting, and I don't remember the discussion about direct the board staff develop a statutory language to establish a requirement for 1 year deadline to complete.
Well, I think because what you have in mind is the last meeting we were at.
Right.
This is, and Ann pointed this out to me, it gets to be rather confusing. These are the minutes for the meeting prior to that.
Okay.
So what,
Sorry, can I?
go ahead,
So
interrupt
what's,
me.
yeah, so what's in the chair report are the outcomes from the last committee meeting, but the minutes themselves are not available because they have not gone back to the committee yet. This discussion happened late in the day, and I'm not sure that all members were able to stay.
Okay. So I have a question about the 1 year deadline. Complete the requirements.
Beg your pardon? You have a question about the 1
Yeah,
year?
I do
So-
too.
Okay. Do you want to, so, getting back to Stan, and if Stan were in a situation where he had to take either the two tests to get his license back, and Stan is now a mature adult, except for a discretion and the practice of pharmacy, and he's got a couple of kids and a family, and he's dealing with a whole bunch of stuff. I don't know if Stan could do it in a year. I mean, it's a rigorous course study to take the CPJE. It's just, and you're an adult. You're not in school, and it isn't the only focus that you have. And a year is a short period of time for someone to re-educate themselves where they're proficient enough to pass either of the two exams.
So, kind of founding on what Stan is, I guess I'm trying to understand why. Why do we want the 1 year? Because I think last board meeting, I think it was, we talked about, and it came out of the licensing committee about if someone has passed one of the tests, that they need to pass the other one within time period of when they're both valid.
Right.
And so I'm thinking that maybe that makes more sense, but I'm thinking also you guys probably had a lot of conversation and you arrived at this 1 year. And do you remember why
No, I don't. I'm just like Stan. I don't remember this because it's the meeting prior. However, we do have a resource here that I know that can enlighten us. But it was mostly for staff's.
So the challenge is, the underlying issue is that a lot of times the board votes to reinstate a license, but then someone never satisfies it. So what happens to that order, right? So we have, I don't know, I would guess 35 to 40 of these where the board voted to reinstate the license, the person never fulfilled the obligation, but that order, that license reinstatement is still out there. So what the board staff was looking for was some sort of parameters under which it would be appropriate. And I don't know that 1 year is appropriate. That's what the committee came, that's the recommendation. I don't know that anybody's wed to that. But the issue is that our law doesn't specify how long someone has. So these orders are in perpetuity. And so we need, the issue that we're trying to solve is how long are you going to give someone to do it? And then we put a statutory change in to implement, to actually effectuate it, because managing these becomes a little bit troublesome.
I
But
understand
Ann,
that. I
what
just
we
think a
did
year is-
last board meeting around the licensing and retaking tests, wouldn't that, it's more than a year, but wouldn't that solve it?
The order itself is not specific to, you have to take the exam that's currently given. You have to pass the pharmacist licensure exam. Do you know what I'm saying? And so if they took one and they never took the other, it would still be out there in perpetuity. So what we were trying to do is give people a reasonable amount of time, and whether that's 1 year, 2 years, 4 years, 6 years, policy decision for the board. What the issue is we need some sort of guidance so that we can do some kind of statutory change, so that both we as the agency have an idea, but also the individuals that are getting these orders have an understanding of what the rules are and how long they are going to have to
How
comply with
about
it.
2 years?
Oh, can I ask one more question before we just grab at
Better
years?
than one.
So I'm trying to figure out, what are we solving for? So let's say the person has to do these 2 tests, and, right now it's within 5 years, so they don't get it, and it goes on to 6 years. So by having 1 year, 2 years, whatever, we're going to force them to reapply to take the test. So let's say you say, before you can be reinstated, you have to pass the CPJE. And our new licensing thing is, well, if you pass a CPJE too far out, then it's not within the same psychometric time period, and so therefore, no good, doesn't match up, doesn't work. So that person, they would have to start all over again, and they would have to basically apply to take the test again, right?
In the licensing scenario, yes. For purposes of the exam, for the discussion with how long an exam score is good for. I think that one of the challenges with a petition for reinstatement of a license is you as the board, you're making a decision based on information that's presented at a specific time, and you are relying on specific facts. People's lives change, things change, and so it becomes this was the decision that you made to reinstate the license under these conditions, December 1 of 2016, right? A lot can happen after that before they're issued a license. So do you want to, if they don't satisfy those requirements within 2 years, have them repetition the board so that you can reassess them and see, did we make the right decision? Have they changed who they are? Do the conditions need to be changed? Because you're making a point-in-time decision, do you know what I'm saying, based on
I sort of
specific
do, but I
facts.
still think that if you have requirements and they don't make them, then they come back to us as they've fallen out of probation, and so now
So
they're
that's
done.
what the problem is they don't come back to you right now, because it's a reinstatement. There's nothing for them to come back to. There's no requirement for them to come back to you, and that's what we're trying to do, is put something in.
What would be requirements for reinstatement that would never come back?
So
Those that
you
had a
lay out.
final-
Gotta find out what?
All of them.
Had a deadline, and so then if they didn't reapply,
Had a deadline to do what? What would the requirement be that they would miss that would never come back to us? Because if it's a
So-
test, it would come back to us.
So
If it's-
I might take a shot at this and see if I can help, because I think I understand what the staff is trying to get at. So when a petition for reinstatement is heard, as opposed to a petition for reduction of penalty, the person doesn't have a license. Most frequently, or frequently, if that happens, the board would say, upon completion of the license exams, certain license exams, then a license will issue. Not until then. So they're not on probation until those conditions precedent occur. And so what happens for the people that take only one of the exams or don't take either of them, maybe 6 years ago, the board in, 2012, the board granted reinstatement to someone, but said as a condition precedent, you have to take the NAPLEX and the CPJE. It's 2018, they haven't taken it. But if they go out in 2018 and they do those things, they can now become licensed.
Okay, and I guess I don't understand what's the problem.
So if they wait till 2024 to take it, they can still become licensed at
Right,
that
and they
point.
still have to do it
So-
within our parameters with license, so they still have to be competent within what we've done for the license. They have to take both of them within X number of years.
Well, they could take
Right.
one year 1 and 1 year 10. That's
No,
possible.
because last time, we just said, no, you can't do that, because it has to be in the same psychometric cycle.
I'll have to look and see
Well,
whether or
no,
not that would
I think we
apply. I
got-
think that might be only initial licenses.
Oh, okay, but that was
think we
in
said
the
that.
licensing committee?
No, that was before
the
the
board
board. It was
It's
in our
the,
minutes
it's a
this time.
statutory
It was in our
proposal.
May 2 and 3 minutes.
Yes, you're right.
Yeah.
You're right,
So
Debbie.
You're right.
I'm sorry, can you say that one more time? I just can't quite hear it.
But they could wait for 6 years to take both of them.
Well, only if the psychometric allows that. So I'm saying, so if you didn't, then you just reapply, and then you would have 6 years anyway. So I'm just trying to make sure we're solving for something. I mean, I understand from the staff point of view, it's so nice to have, I mean, I'm a pharmacist, we love black and white, and I get what you're trying to get at, but I don't think we're solving anything.
But I'm sure in most cases, the pharmacists, if given the opportunity for a reinstatement of the license, they were the first one
They're
to
gonna
jump
move.
right ahead and get the exam done rather than waiting for another 2 or 3 years. They know how tough it is to come in ask for reinstatement. If given the chance, I wouldn't think anybody want to wait 2 years. But I agree with the staff, you have to put a time limitation on it rather than dragging their feet. So given that the circumstances that we're going to give you a year to finish, if not, then you got to come back and explain to the board, what happened.
No,
Or they have
but
to
would you
petition a
have to-
waiver or something to extend that time period to finish the
But
exam.
would you have to come back to the board?
No, it doesn't address that.
So,
Because if we said you just have to pass both licenses, and you don't do it within that number of years, then wouldn't you just do another application?
you would petition again for reinstatement. If the petition, as it were, the 2012, whatever the year was granted, but it had a time limit on it, then it would cease to be effective. And so the person would revert to being revoked.
Or
And so
if,
then
once
they
we
would
get
have
our
to
new
petition
license
again.
psychometric thing in place?
But they would have to, because they were revoked, these are only people who were revoked in the first instance. The people that you're talking about have all been revoked.
Okay,
Otherwise, they
all
don't
right,
petition for
So I guess we have to make
reinstate.
sure that on renewals, that the psychometric is, if we miss that, and on reinstatements, they don't have that same psychometric rule, then we need to fix that.
And how do we do that?
We just go, I mean, because it sounds like what we passed last time was only on the first time you take the board. So if you're doing reinstatement, then you could take one test 20 years apart.
Right.
And so if we did set that up, we messed up, and we need to fix that. Because we can't have people reinstating, not having the same bar as new license.
So next time when we apply that, for them to take both the licenses, we have to specify they have to take both within the same psychometric cycle.
I guess the other way we could do it.
Is that okay to specify that?
You could, but if you want to do it as a pattern and practice, you need to put it in your disciplinary guidelines. If you want to have that be your standard, it should go in your disciplinary guidelines.
Let's
So
do it.
you would,
So we
I mean,
might have to-
anytime the board
mean, our-
makes a decision, it can decide what's appropriate, but realistically, if you want it to have to be a rule of general application. It should be
And we
in the-
should
in
probably
the guidelines.
change the reg or statute that we voted on last time to include reinstatements also, right?
You know what, honestly, I'm blanking on exactly what it was, but I would definitely look at that.
I think we can do it with wording, like, an exam score to be valid must be earned, and that's pretty close to the actual wording of the statute, and for all uses by the board. I mean, and then when you do the reinstatement language, what's going to be required for the reinstatement, you just refer back to that. I mean, that might be able to just be done without a big deal.
And
So the only other thing that I'd just like to highlight is we license more than just pharmacists. So this applies to license categories where there is no exam as well. So it applies beyond just pharmacists, the policy of the enforcement committee.
That makes sense.
However, I
That's all I
want,
was asking for.
that's all you were asking for besides
For
the
situations other than the,
okay, it sounds to me like the discussion is not current in our minds.
I make a motion that you table it.
I think that's a wonderful idea.
okay,
Okay, do we have to vote on that?
Well, you need a second and then a vote.
How about a second?
second by Albert. Okay, do you want to take a vote? Do you need,
All those in favor?
all those in favor, please raise your hand.
what are we being in favor of?
Table it.
Table it.
Don't we just vote it down?
Oh, we're tabling.
I think we just don't have to do anything, don't we?
The table take preference, though. Okay,
Under Robert's Rules of Orders, at least.
All right.
okay, Ellen.
Okay, so far.
Public
we-
comment as well? Public
What?
comment?
Oh, public comment. Any
okay. Any
Please,
public-
no
any
public
public
comment, but
comment?
feel free. Okay.
All right.
Nobody's, oh, God.
Oh, Steve?
Can I get that in the minutes, too?
Steve Gray, pharmacist.
Yeah,
I
his
was
name's
at that
Steve, not
meeting,
God, so
and I remembered the discussion a little bit different, that it also applied to petitions for reduction in penalty, not just reinstatement. And I was thinking, for an example, that if you ordered for the reduction in penalty, you ordered like continuing education hours or community service hours and so forth, and those were just never gotten to. These petitions, whether it be for reinstatement or reduction, just kept going on and on and on, and they were never closed. So rather than table it, I think, quite frankly, it needs to be referred back. Clarification, and because I do think that, you know, it's a legitimate concern of staff to get some kind of closure and direction on these things rather than. I know from counseling of people who want reductions in their penalties. Don't know what to tell them right now. Do you have to take, you know, what's the timeline? What happens? Is it fair to have someone take the exam and then get reinstated after the scope of practice has changed because the next thing came into play and wasn't? I refer it back to committee.
Oh, that's a good idea, Steve.
I think I would be on board if it's like CE and, I mean, stuff
Let's
like
not
that.
discuss this here. All right. So do we need a motion to take it back to committee?
So we're gonna not table it, is that it?
Well, tell me,
We're tabling it, but it's going back to committee.
yeah,
For
yeah.
refinement.
yeah, okay. All right. Am I still on here? Okay, discussion and consideration of potential statutory and regulatory amendments to allow a reverse distributor to accept medications for destruction in limited circumstances from a previously licensed. Yeah, those were kind of both together.
Both together, okay.
Broke my stride there.
Sorry.
Okay. Presently, the BPC Section 4040.5 provides the definition of a reverse distributor as an entity that, among other functions, manages the disposition of outdated and non-saleable dangerous drugs and devices from a licensed source. We have a motion to allow them to pick up these items from a previously licensed source. Right now, the law does not allow for a reverse distributor to pick up items from a business that's closed. So the committee recommended a motion to direct staff board to develop a proposal to allow for a reverse distributor to take back some medications from a previously licensed source. Is that okay?
And that's the committee recommendation?
Yes.
Okay. Any other comments from board members? Any public comment? All right, then the call for the vote. All those in favor, please raise your hand.
Thank the Lord. All right.
Oppose or abstain? One abstention? Okay, motion passed.
Okay, item number 4D, discussion and consideration of current board investigation timeframes and performance measures, partially covered by Josh's presentation. But now, one of our strategic goals is to implement processes to shorten the cycle of times from the initial investigation to the resolution of cases. We have a variety of benchmarks. The assignment measures the time from the date the complaint's received or initiated, investigation, duration from the date the matter is assigned to the date the investigation report is submitted, review times, and closure times. In addition to these measures tracked by board staff, the department established an enforcement performance measures as part of the Consumer Protection Enforcement Initiative. This data is typically reported on a quarterly basis for all programs within the DCA. Most recent reports available is for the April through June reporting period. However, it's the board's staff's understanding that more recent data should be published in the coming months. When that report is available, it'll be brought to the committee for review. And attachment 3 includes a 3-year comparison, which everybody's going to turn to right now. Number E is discussion of the presentation of the administrative case process and case resolution times for matters referred to the Office of the Attorney General. The committee members have seen this twice. It's Josh's presentation, and interestingly enough, on the second presentation, it became even clearer. And so, so if you didn't catch it, maybe you can watch the WebEx of this. Yeah. Okay. Can we get that in the minutes too? Okay. F, the discussion and consideration of implementation strategy for the anticipated statutory changes to incorporate USP compounding chapters. Background, during its May 18 board meeting, members voted to pursue a statutory proposal to incorporate USP compounding chapters into the board requirements for compounding. As part of the discussion, the board noted that 2 of the compounding chapters, 795 and 797, are in the revision process, and 800 has been finalized but not yet in effect. Chapter 795 were released in March 2018, and an open mic session was held in April 2018. And in addition, in May 2018, it was formally published in a pharmacopoeia forum for review and public comment. The public comment period will close on July 31, and its intended publication date is June 2019, with an implementation date intended to be December 1, 2019. Similarly, 797 is going to be pre-posted by the USP July 27th, 2018, and will be formally published September 4. Open mic session will be held on September 5, and a public comment period will close November 20. The intended publication is June 1, 2019, and an implementation of December 1, 2019. Chapter 800, it's in its final form with the expected implementation of December 1, 2019. This is to coincide with the anticipated official dates for 795 and 797. As the revisions for the respective chapters are finalized, it's anticipated that staff will complete a comprehensive review of the new requirements, provide recommendations to the board about the changes to the board's regulations that are going to be required. Further, the board's current regulation requirements related to hazard drug compounding will need to be reassessed to determine if any action is necessary. As part of its discussion, the committee heard from members of the public on the readiness to meet December 1st, 2019 requirements in USP 800. Based on the information received, it appears independent retail sterile compounding sites will be compliant with USP requirements by December 1, 2019. The committee requested that information on the readiness of other sterile compounding pharmacies be provided at future meetings. In response to the public comment and the recognition of the large impending policy work that will be required after the finalization of the USP chapters, President Law has bifurcated the Enforcement and Compounding Committee into two committees. Obviously, the Enforcement Committee and the Compounding Committee. And that transition will be occurring during the next Enforcement Committee scheduled for September 8th. Okay. Number G, discussion and consideration of the board's enforcement statistics. During the meeting, the committee reviewed enforcement statistics. As part of the committee's discussion, staff was directed to incorporate additional reporting elements, including proof of abatement orders, average investigation time, strategic goal measures, and cease and desist orders issued for unlicensed activity. Remind me about proof of abatement orders. What's that mean? Anybody? Josh.
Wow, we're all racing to the mics. Look at that. We had 4 of us.
That was a good question.
Well, so basically, in a citation, there's the fine, but there may also be a requirement that you do something to abate the behavior. So it could be submitting documentation proving that you've come up with a new way of keeping your inventory, or may require you to install additional cameras, things like that, to abate whatever the violation was.
All right, all right.
Policy on
It's just
something,
amazingly
so
clear once you
submit the
describe that.
policy.
I'm disappointed nobody else raised their hand. Okay. Any public comment on this, on the previous discussion and consideration of implementation strategies for the USP compounding chapters? Steve, good to see you again.
Ray, pharmacist. Under Section G, if I remember correctly, Alan, this is where you ask for additional statistics related to the goal of doing or about enforcing consultation, prescription consultation. Wanted that, if I'm correct, separated out from the other statistics. Discussion, you wanted to change the strategic goal recommended by the enforcement. Correct? And we may have a.
The committee had discussion about strategic plan in general. That is not on this agenda or in this chair report because the board is going to be taking up all the strategic plan issues from all of the committees during one meeting.
So you're correct. You're correct, but it's going to be in the future meetings. We're going to address that.
Not this month.
Not this month.
Thank you.
Yeah, Danny?
Good afternoon, board members. Danny Martinez with CPHA. Just want to reiterate our commitment to working with the board on the USP issue with the statutory proposal. We're sending out a note to our compounding pharmacists to make sure that they get their comments in for 797 when that period opens. And we hope that they've been putting them in for 795 as well.
How many do you have, Danny?
I'm sorry?
How many do you have? Do you know?
Compounding pharmacists? I don't have a number off the top of my head. I can get that to you at the next meeting. But again, just want to reaffirm our commitment to getting this done and, willing to give any resources necessary for us to make that happen. So, thank you.
Thank you.
Do you think that we as a board should be putting any comments in for 795 or 797? I said, do we think as a board that we should be making any comments on 795, 797?
I don't think as a board we have the expertise to do that. We have the expertise to direct our inspectors to inspect, but as far as comments, I don't feel any of us have a good grasp of those to make an appropriate statement. Don't you feel that way too?
I feel like I really don't know about compounding, so, but I just, if there's a certain way that we kind of want 795 or 797 to go, because we did go through that laborious process over many years, to try to put together regulations and statutes. I just wasn't sure if, in looking at 795 and 797, if there's any expertise, and maybe there's not, on the board to say, gosh, that little section's maybe not going to hit the mark for us, and we should make a comment.
We do have some expertise. Maria Serpa actually is a compounder. She can discuss some of this. Now, the degree to which she wishes to become the board's expert in this area is a different question. But I do know that, I know just enough about her to know that she does have that as part of her skill set.
And also, I like to add that on the compounding subcommittee, we do have Dr. Maria Serpa as one of our member. Was in addition to Shirley, me, and Alan, you'll be the vice chair, and then we have the honor of Stan going to be the chair of that committee. So you guys will be in charge of doing all this stuff.
And looking forward to it. Yes, okay.
Thank you, Alan. Beef, yes.
Great pharmacist. I would echo what you said, both of you, that I believe that the board staff, through their extensive training and so forth, and have gone through, and I've heard lots of discussions about 795 and 797, have a lot of expertise that should be shared. We identified in California generally that there were inadequacies in 797, and that's why California decided to go down its own path for its own regulations. Now that the board, as I understand it, has decided to basically start leaning to deferring more to 797, I think this is an opportunity to share with those folks regarding 797 some of the learnings that California has had where there may be inadequacies. So I think there's, maybe not in the board members themselves, but in terms of board staff and with help from board members like Maria, that it would be a missed opportunity not to provide some input, even if it's just confirmation that the 797 drafts of 795 are better than they used to be. I think it would really be important to share that those points of view.
Well, we have to get. You make a point. You make a good point. But and I was a little bit superficial in replying to Debbie's comment there. But we have to hurry up and do that because it looks like we just got about 2 months to do something like that. And I'd look to. Let's see, who
can you look to? Huh?
Yeah, who can I look to? What would be the process to do that?
Well, we need the final chapters first, and that's we're not gonna really have those until the spring of next year.
So,
But we'll kind of have a direction once we get the guidelines or where they're going.
so I think if the board was interested in having staff provide comments on the current drafts of it, we could have our compounding experts look at and identify whether or not there are provisions that they think are problematic. I think, though, that the board's direction was going to be adopting 795 and 797 and 800, and then those that were incorporated as minimum standards,
Right,
and then
minimum,
doing a gap analysis. So I think that we could address any deficiencies in those chapters through our traditional regulation process, which is what we, I think, envisioned the process being moving forward, and the bifurcation of the committees and everything.
One quick suggestion that I would have, because I know several of our compounding pharmacists had mentioned this, a suggestion would be a joint task force between board and CPHA compounders to kind of come up with solutions that we can all agree on in terms of compounding regulations and how it would interact with 795 and 797. I know that some had expressed a disinterest in that in the past, but I'm revisiting it again just because if there's a desire to have an expert, like a panel of experts, expertise, I know that our compounders would love to assist the board with any sort of help that they needed on that. So just a suggestion that I know that several of our members have made, making it public now. So something to think about if you guys are interested.
I'll leave it up to the committee chair to decide it. Thank you, Danny.
Well,
One
you
more
know,
comment? Take your time.
Oh, they're glam ones, so.
Hi, Christine Versko with Dyna Labs. I want to reiterate that changes in 797 and 795 and 800. Trust that you guys do review it, or experts help you understand it. And there are things related to BU that are quite different. And
Related to, what was that? Did you say?
assignment of beyond use dates.
Oh, uh-huh.
So, as a company that works with USP all the time, we're willing to bring some expertise to you as well.
Thank you.
Well, keep in mind that the public comment period will close November 20 this year. And so
There is public comment from our company. There's a couple of other companies that have made public comment. So I have some of those documents that more reading to do, but you know.
Well, my concern is that if we we'll have to, the logistics of doing this are going to be kind of tough, because usually we would want the committee and the board to review anything that we'd send into 797, I would think.
What if the board instructed the committee to work with expertise on the staff and the chair and the executive officer,
That was the plan of the chair.
yeah,
Yeah.
to go ahead and, I think we can,
Let the chair speak.
so, okay, the chair, I'm sorry, the chair and the executive officer to put together a comment to send in without having to come back to the board and for a thumbs
Okay,
up.
thank you.
Can I make that a motion? That would be
Second.
helpful.
I would like to just, I mean, Jenny can say this or Stan can say this, but I, having been through the process for decades, it took 10 years to get from the start of a compounding task force to even a draft version of the board's current compounding regulations. The idea that any kind of agreement could be reached on comments that might be made between now and November to submit comments seems impossible to me, but that's just my personal experience on how these things tend to go.
Decades of experience.
Well, so we can still give the chair and the executive officer the ability to do it, and
If they fail?
if they don't come up with, something that they feel like that they are in sync with, then we don't send a letter. But I just don't want it to have to sit and wait to come back to the board.
Okay.
So, and I would recommend that you ultimately give one person the delegated authority to take care of some Open Meeting Act issues. So one person makes the decision, and then another person could provide input. But there needs to be a
So
final.
do we normally do that?
Either that or you
executive
can, they
officer
could
makes
do
a
it by a
decision and-
meeting.
We've done it both ways. We prior, for example, where we've done this before was providing comment on FDA guidance documents, where I would generally work on comments with, and compile them, and then work with one board member to submit them on behalf of the board, and then after the fact, we'd bring them back to the board for them to share. Because the timelines usually fell between board meetings, and like you said, it becomes a lengthy process when we have to build in that additional time frame. So we've used this system before. USP, the three of them are certainly more extensive, so there could be some pretty comprehensive comments, but maybe there won't be. Maybe there'll only be 3 things that we'll end up really wanting to stress with respect to our comments, too. So,
Is that okay, Debbie?
yeah. I think that we're providing comments on behalf of the board, I think.
You
that-
okay, Stan, you seconded, are you okay?
Oh, yeah, I'm fine.
You look good.
That's it?
Oh, we're good, that's it, so
That-
we'll.
That's
go
it for
ahead.
the report?
Dan and
Yeah, we have
Debbie.
to vote. We made a
Public comment?
motion.
Any more public comment?
Motion, we need
I
to
don't,
vote.
I don't think there was a second.
comment.
Yeah, Dan and
Oh,
Debbie.
there was, sorry.
Okay, that was motion by Debbie and second by Stan. All right, we could take a vote. All those in favor, please raise your hand. Oppose? Abstained? Motion carry. Okay, thank you. Thank you very much, Alan, for your report. And let's see. Should we go to item number 8 or should we adjourn for the day? Board members,
I think we go.
time to go?
No, I think, yeah, go to 8. Let's
You
do
want to
8.
go? You want to go one more item?
Yeah.
Or we-
Oh, yeah, sure.
Oh,
So we do, sorry to
Yeah, yes,
interject,
yes.
we will lose the closed captioning at, in about a half an hour. And I don't know how long the presentation is, but we would need to stop potentially in the middle of the presentation.
Oh, how long is the
long you guys
presentation?
At least 4 5-minute breaks. No, I'm just kidding. It's relatively short.
Okay, if it's short, we just go ahead. Okay, item number 8, presentation on the Open Meetings Act and Conflict of Interest. Okay, Laura? Kelsey?
Oh, you thought, it went over my head. I did.
Short and sweet. Unlike Josh, we don't want, or Mr. Shad, we don't want to have a 3-time.
Practiced.
Thanks, Laura.
I think. We're on licensing. You're queen of licensing.
Are you on licensing with me? But can you be, because you're on so
While
many
the handouts are
things.
being passed out, I'll just start
Look, you're on 3
on our
committees.
intros here. Again, I'm Kelsey Pruden. I'm with the Department of Consumer Affairs, Office of Legal Affairs, one of your assigned attorneys. Am I, oh, there we go. I need to, okay. So, we're going to give a fairly short, although very riveting, presentation on the Open Meeting Act and some conflicts of interest. This presentation essentially was developed by the department. It's been given to the other boards and bureaus in the department, and it's a good refresher course and also a good introduction to our 2 new members. So our 2 objectives today are to create an awareness and then to also about certain situations that might arise and potential dilemmas that can occur from these 2 things, Open Meeting Act and conflicts of interest, and then to suggest some strategies for you as board members to resolve those dilemmas. We're going to cover the Open Meeting Act and disqualifications and abstention, the need to disqualify yourself or abstain from a voting on a particular board issue when you have a personal interest or a bias. So I'm going to open it up with the Open Meeting Act. It's a law that's purpose is to promote openness or transparency in state decision making. And it imposes 3 duties on your board. One is to give adequate notice of meetings that will be held and items that may be discussed. It's also to conduct meetings in open session and to provide the public an opportunity to comment. And it's really intended to permit the public to know what the board will be discussing, give them that knowledge and that opportunity to participate in the making of any decisions. And the public can't have input if it doesn't know about the meetings, hence the requirement to have notice. And the public can't have input if a meeting is held or a collective decision is made behind closed doors via email or anything like that. So this law provides an opportunity for you all to alleviate any perception that you're doing any quote-unquote backdoor dealings. And part of that is that public perception is really important. And the board is comprised of
government officers. And as a public officer, one of your mandates is protection of the public, but it's also to ensure that there is public trust in your board as well. And that's really what the Open Meeting Act tries to facilitate. So what meetings are covered by the Open Meeting Act? Generally speaking, the Open Meeting Act applies anytime you have a majority of your board or a majority of a committee of your board discussing or taking action on matters within the jurisdiction of your board. And a majority means the number of members currently appointed to the board, which can be distinguished from a quorum, which your statute sets at 7. And the law prohibits a majority of the members of a state body from using direct communications or a series of communications of any kind directly or through personal intermediaries or technological devices, such as emails, to either discuss, to deliberate, to take action on any item of business that is within the subject matter of the state body. And that's under Government Code Section 11122.5b. And it also requires that any multi-member body that exercises any authority or a state body delegated to it that by that state body is also a meeting. So there are some exceptions. Meetings of a committee that consist of less than 3 persons, and although in this situation persons can mean anybody, it doesn't necessarily have to be a board member, whether or not, and then an example for your board is the org development committee. Individual contacts or conversations between board members, as long as it's not a series of conversations with other members on a particular topic. Participation at a conference or similar gathering or at an open and noticed meeting of another state body or legislative body, provided that a majority of the board members do not discuss amongst themselves other than as a part of the scheduled program or meeting business of a specified nature that is within the subject matter of the board. And the last exception is purely social or ceremonial functions, such as board members getting together for dinner before a board meeting. Granted, you're not discussing board business. So I'm going to kick it over to Laura now for a few examples.
So in our sample, which was developed some time ago, we have a hypothetical board of arborists. And the example that we have is if one of the members sends an email to all the other members saying, hey, I have a great idea for legislation next year. I think we should all have continuing education because that'll improve the public image of our protection. Here's a position paper. Could you take a look and tell me what you think? So the problem with that kind of communication is your one person is basically inviting each of the other board members to comment and provide feedback. And so those kinds of things we discourage. We don't want you to have those kind of, we call it collective communication, because you're violating the spirit of the law if you have that concurrence before the board meeting. The Open Meeting Act requires that discussion occur in this type of forum where people can see what the decisions are that the members are making. And so if you do get that kind of email, what we recommend is simply that you reply back and say, hey, can we just put this on the agenda? This really is probably appropriate for the next meeting. And then also, we also recommend that you notify the EO so that the EO can follow up as well. You can also reach out to your legal counsel. That's the third option. The other part about it is, and this is really important, knowing violations of the Open Meeting Act are actually misdemeanors. And so this is one where we tend to be very conservative in our advice to board members because we don't want ever for the members to be put in a position where they could get in trouble. The other thing that you should know is that any action that's taken in violation of the Open Meeting Act could also be undone, and that's also a significant issue. So those are the reasons we're very conservative. There's also a public perception issue, obviously, if that's happening, and we don't want that either. That same analysis applies if it's a series of telephone calls or emails or now texts. we have these materials go back a few years, probably before there was a lot of texting going on, or social media, same kind of thing. So it doesn't matter the medium by which the communication happens. The importance is that there shouldn't be a collective communication or discussion, either one person reaching out to all the others individually, or simply a group chat, if you will. Either way, we don't want that to happen. And that applies whether it's a member that does it or it's the staff. It could be your executive officer can't do that either. Once you start hitting that quorum, it's a problem. So if you do have a question, sometimes it's okay to reach out to the executive officer or staff and say, how is this? Or to reach out to like one other board member, just to make sure that you don't end up inadvertently creating what we call a daisy chain, where you end up making a decision without it being part of an agenda.
So I'll do the next example. This one is for social occasions. And we're back to our board of arborists, and they're at a table together at a reception during a Federation of State Board Arborists annual conference. And after chatting together about the location, the quality of food, and the drink at the reception, one member brings up a bill that would require fingerprinting of all licensees at the time of renewal. This also dates us, right? How old this is. But our advice there would be to not talk about the bill. You're all there not acting as board members, but the moment that board business gets brought up, it would be a violation of the law to discuss it in that setting. As a precaution, it might be prudent to establish with your fellow board members, hey, we're all going to be here. Let's make a point of not discussing any board business.
So the final example in this area is about new board members, and I know we have 2 new board members. And unless you've been devotedly following the board and attending meetings and following along, there's a lot of time there could be a knowledge gap. So what our recommendation there is that we want you to become knowledgeable. We want you to have the information that you need to make good decisions and to prepare for board meetings, but that the number of contacts that you have are somewhat limited. Obviously, you've got excellent staff that you can go to obtain information and background, and then just don't speak with the majority of the members. So your task is to sort of limit the number of contacts that you're reaching out to as a new board member, so that you don't inadvertently violate the act. So our next topic is the disqualification and abstention. And so we're going to kind of deal with this in 2 different contexts. One is going to be in terms of discipline or licensing matters, so the enforcement matters which Josh was talking about. And then the next context will be more globally in terms of policy decisions that the board makes. So in discipline and licensing matters, we talked about this briefly, and I mentioned it while Josh was talking. And that is that you're acting as judges. You sit on the dais and you evaluate the evidence, and you are judges. And actually the law that governs all those processes, the Administrative Procedure Act, actually specifically assigns some of those same duties to you that it does to the administrative law judges that hear the cases sometimes in the first instance or hear them with you. As a judge, you have to be fair, you have to be objective, you have to be unbiased. Those are both the requirements of due process, but they're also codified in the administrative adjudications, what they call Bill of Rights. And so disqualification means that you're ineligible to act on a specific matter before the board, and because there's actual or perceived bias or conflict of interest. Disqualification, that term is usually a term of art used to mean that it's a mandatory disqualification. So when we say disqualified, means you're not able to. Abstention, on the other hand, is voluntary. And usually we try to distinguish them. Sometimes we mix them up, but usually one is mandatory, one is voluntary. And abstention means that the member is choosing not to participate because they're concerned about it, or that they've made the decision that they feel like it's better if they don't participate, either for their own reasons or because there's a perception issue. In deciding whether you should participate in a specific matter, you can ask these types of questions, and each of these corresponds to provisions that are actually in the Administrative Procedure Act. And one is, have you served as an expert witness, consultant, investigator, prosecutor, or advocate before or during the adjudicative proceeding? Josh spoke about that earlier, and I alluded to it that Kelsey and I, in our role as counsel to the full board and the members, we very deliberately avoid participating in the specific cases that the executive officer as a complainant is working with her counsel at the Deputy Attorney General's office. So that is a different role. If I step into that role, I can't advise you because I would be disqualified. And so we're very cautious about that in our office, and we take steps to do that. And we ask that the board members do that too. So we'll get into ex parte communications in a bit, but it's the same principle. If you've been involved in the underlying investigation, if you did some discovery, so for example, particularly for the licensee members, if you are the employer of somebody who maybe did something wrong, and you did some investigation or did the report to the board, you would automatically be disqualified from voting on that. It's for those members who've been around for a while. I don't think this is a surprising result. The next question is, are you biased or prejudiced for or against the person, or do you have an interest, including a financial interest, in the proceeding? Again, that is a required disqualification if any of those are true. The next question is, have you engaged in a prohibited ex parte communication before or during the adjudicative proceeding? And this could result in a disqualification. And that's a very fact-specific question. If that happens, and we'll talk about that in a little bit more, we encourage you to reach out to one of us so we can evaluate that. But generally speaking, that's going to happen if the applicant or a licensee or someone acting on the person's behalf, it could be an attorney, it could be their sister or brother, parent, child, complain to you about an investigation that's in progress, or said, glowing things, hey, I'm terrific, whatever it was, the same issue arises. We don't want to have that ex parte communication, because when you make a decision as a judge, you're restricted to the information that's presented to you through the process. And that process is very rigorous, and it's very tied based on the confines of the Administrative Procedure Act. And so we expect you to follow, you're expected to follow that as a judge. So in that context, you could be disqualified depending on the nature of the contact and how much information was shared. The next question is, do you or your spouse or a close family member, such as an uncle or cousin, have personal knowledge of a disputed evidentiary facts concerning the proceeding? And I'm sure we've all been on juries, and this is kind of the same idea that we're getting at here, is if you have too much information or have access to the information, the idea is to determine whether or not that could lead to disqualification. That's not a mandatory one, but it is a fact-specific question. Do you doubt your capacity to be impartial? And if the answer is yes there, then that is a mandatory disqualification if you have that doubt. Do you, for any reason, believe that your recusal would further the interests of justice? And that's on your own decision to make that. If you believe that either for public perception reasons or because because there could be an appearance of conflict, or that you don't want the decision to be invalidated because maybe that person has objected to your participation. You feel you can be neutral, but maybe it's just not worth, participating to run the risk that it would somehow invalidate the decision. And that's not mandatory, but that's permissive. And finally, if have ever had a family or social or professional relationship with the licensee. And those members who have been around a few times, usually we just discuss those. And certainly if that comes up, we encourage you to talk to us about that. We'll go through the steps to see whether or not we think that it's a too close of a relationship and that you might want to recuse yourself. But it doesn't always lead to that. And we have several examples of that in the recent past. At this point, I can point to handout, the second handout. I think it's labeled handout number 2. It's a chart, and it basically reiterates those points that I just gave you, and you can see where there's the mandatory disqualification and where there's the permissive. So if you do disqualify yourself, we encourage you to put your disqualification on the record. You remove yourself from the deliberations and voting. So meaning you don't participate in the process. If it's a petition for reinstatement, you would probably step down for the dais, you wouldn't ask questions, and you wouldn't be in the closed session. There is one exception that we have had to use on occasion, although with the full complement of board members, it may not come up, but that's if we have a short number of people at a meeting and we might lose quorum. So on occasion where there might have been a disqualification, if we need 7 people sitting at the dais in order for the board to be able to make a decision. They need that we need that to effectuate it. And generally what we recommend is that you simply abstain if we have you retain in order to make that 7th person. But as long as there's 7 non-disqualified members, then we'll probably recommend that you step down from the dais and leave the room. So, and now Kelsey gets to do examples.
I guess the point of my example is that it doesn't just end at the vote, a recusal or abstention. So for example, if you recused yourself because your best friend had an issue before the board, you recuse yourself, the board votes, but then after the vote you say, well, hey, let me tell you about my best friend. There's still the opportunity for reconsideration. So it's imperative that it continue and that information doesn't come after the fact of the vote either.
Okay. So in the interest of time, because I see that we have 9 minutes left, maybe we'll slim down our examples. Are we good with that? Okay. All right. So if you do choose to abstain, that doesn't require that you not participate. It does allow you to sit at the dais.
Can I ask about abstaining on mail votes?
Yes.
So when you abstain on mail votes, do you want us to call, because it seems like there's like a little spotter. It kind of makes you want to type in there why you're abstaining. Do we need to do that, or can we just abstain?
So under the Political Reform Act, which we are going to get to in just a second, if there's a financial conflict of interest, I believe the Political Reform Act's requirements actually require recusal, which is what we use when you're talking about disqualification. And then we would recognize it because it needs to be stated for the record, and we want to create a record that you've recognized that you have this conflict and that you're not going to participate you're affirmatively excusing yourself from that matter. But I think where you have a standing case, I think that's less of an issue. So I abstain, generally speaking, and I don't remember on the mail ballot how it's looked at.
I mean, in my
Maybe
case, with the mail votes, I usually abstain from people who work for the same employer as I do.
Right.
So do I need to state that every single time?
I think you could simply say same employer. Do you need to? No. I mean, I think maybe the more important one is if one does pop up that's not related to that, then you might need to specify that. Skipping ahead to the kind of ex parte communication. So ex parte communication is a specific term of art, again, used in the Administrative Procedure Act, and which ones are permitted. So there are a few that are allowed, and ex parte by its definition means that it's one party communicating with the decision maker without the other party present. So as I said, your executive officer is a party to any licensing or enforcement cases. So your executive officer then can't speak to you in general without the presence of the respondent. So the licensee or the applicant would also need to be present, or it's considered an ex parte communication. And obviously outside if it wasn't to everybody, then there'd be another issue. There are a few exceptions to that, and they're created by statute. So if it's a matter of procedure or practice that's not in controversy, so the board member can always ask, we have a can we change a proposed decision without reading the record, so without getting the transcript? You can ask those questions procedurally. Those are authorized. But the member cannot say, and basically, and the EO or the staff person cannot answer whether there have been other complaints filed against a licensee. Because the members, as judges, you're restricted to the record that you have before you. So you're not allowed to go outside and obtain information that's not already part of whatever's in front of you, and also to get that specifically from the person. Another reason that you're allowed is for the purpose of assistance and advice from a person who has not served as an investigator, prosecutor, or advocate either before or during the adjudicative proceeding. And the perfect example of that is Kelsey and I. So we specifically keep ourselves clear of any particular cases so that we're available to you if you have questions, either on an individual basis or when we speak to you in closed session. And we do the same thing on petition cases so that we also can assist you with those. And finally, there is an exception if there's a settlement proposal for the purpose of advocating for a settlement proposal. Then, as you know, your executive officer or the DAG can participate and submit information to you without the participation of the other side. If you do get an ex parte communication that didn't fall into one of those exceptions, then if it's an email, then we say stop reading, send a copy to your EO or your enforcement coordinator, and that can include our office, with the date received, whether or not you read it, and any other information that would assist in determining whether or not you can disqualify yourself. If you get oral communication, and I know this happens frequently for all of our clients, you try to stop the person as quickly as possible and let them know that you can't speak with them about any pending matter, and especially kind of let them know that if they do continue to speak with you, that ultimately they're going to kind of get the opposite of what they're trying to get, which is if they keep speaking to you, ultimately you're going to have to disqualify yourself because it's required because you'll have information beyond what's in the record. And then, of course, you want to advise EO enforcement of that so that the recusal can be on the record. And that's also, by the way, those provisions are also included in your administrative policy manual, so the board member policy manual. It allows the members, by doing those, sort of shutting those things down quickly. I don't think that you're disqualified as long as you sort of stop reading and go, oh, I see where this is going. Nope, I can't participate, and limiting it. So that helps. I'm going to skip over our examples. 3 minutes, honestly. So the next questions, I don't know that we're going to get to this, and I don't think I can do it in 3 minutes. So how would you like to handle this? Because I think the remaining portion has to do with like professional association memberships and conflicts of interest that come up at contracts or financial conflicts of interest under the Political Reform Act. And incompatible work activities. So I guess in the briefest of brief, I'll tell it, and then if you want me to continue tomorrow, we can. But if you have any financial conflict of interest that affects you personally, it affects any of the people that you report on your Form 700, or it affects your immediate family, either a dependent or a spouse, then you're conflicted out under the Political Reform Act. You cannot participate. There are a few exceptions, but they're few. But the big message there is identify those as quickly as possible, and then we can do the analysis. The analysis is not a particularly easy one. Under the Political Reform Act, the consequence is that you could be fined. It does not invalidate the board action if it happens. And we can deal with those situations on a one-on-one basis, ideally outside of a board meeting, if we know they're going to come up. So I think am I right about, I've got 1 minute? Okay. Is there anything else that you think we should add in our 1 minute?
What about membership in an organization bill that they?
Okay, so membership in the organization is for a professional organization. The key there is to recognize your role. So if you're the president of that organization, we're a little bit more sensitive to that, because in that capacity, it could look, so the DCA's incompatible activity policy prevents exempt appointees, including staff or members, from engaging in conduct that could create an appearance of impropriety. So if it looks like you're using your position for private gain of yourselves or the private gain and advantage of another, then we say you shouldn't do it. But that's under the department's incompatible work activity policy. So that's where the association, if you're part of the association's administration, generally speaking, our advice would probably be to recuse to avoid that appearance. So if membership is less of a concern, yeah, because you're not steering the direction. You're not. The big issue is that you're wearing two hats. You have competing interests, or you could have competing interests.
But if you're a leader, like if you're the president of the organization, then it might be a little different.
Yes, it might. Where there's an issue that's brought forth by the organization, yes. So I'm concerned that we're losing our closed captioning, so I don't want to keep going. That was I rushed the end, but if you'd like, we can continue tomorrow and kind of go into that in more detail if you'd like, but that's at the board's pleasure.
Okay. Yeah, I think based on time limitation, maybe we should stop here, and you could proceed the rest tomorrow morning. Is that okay?
Sure.
All right, and we could save the public comment until then too?
What I would maybe recommend, see if there's somebody who's not going to be available tomorrow, if they...
Okay, if any public who's not available tomorrow, they want to make a comment, please come forward. If not, that would conclude the meeting for today. We shall reconvene tomorrow morning at 9 a.m. Okay, meeting is adjourned. Thank you very much.
I'd like to announce that the best board member has given me 100.